Good afternoon, everyone. My name is Darren Sall. I'm your employment lawyer for today. Thank you for joining me with another employment and disability law Q&A. Samfiru, Tumarkin, Canada's most reviewed law firm here, employment law firm. Again, I'm Darren Sall. I'm coming to you from Vancouver. I practice in Vancouver and Alberta, and I'm here to answer all of your employment and disability law questions with respect to any matters occurring in BC and Alberta. But if you're Canada-wide, feel free to jump in and ask questions. We're here to help. We're here to offer what guidance and suggestions we can to help you in any employment and disability situations you may find yourself in. If you have questions about maybe things that have happened to you in the past or things you're worried about happening to you in the future, this is your time to hop on and get a free chat here. If you're shy or if you have issues that you don't want to discuss online, I know a lot of these can be very personal. Feel free to reach out to our firm directly. You can speak to myself or any one of my colleagues across our offices in Alberta, BC, and Ontario. And you can go, I think the information's there in the corner there, employmentlawyer.ca. You can go online, speak to someone in our helpful intake team, and they can set you up for a consultation to have a chat and have any questions you have answered. Barring that, you can come in here and just fire away. And I'll do my best to give you the answers I can online. I always say there's no question too small to ask in these sessions. There are sometimes questions that are a little too big, and if that's the case, I'll usually do what I can to give you some direction and have you give us a call with more documents and information. I got a couple topics that I wanted to hit on today. It's been a couple of weeks since I've seen you guys, and so I want to wrap up some old topics and talk about some hot topics that have been going on, some happenings in the news recently with mass layoffs, not only in the tech sector but in a lot of other areas as well. So I will hit on that. If you have specific questions, feel free to jump in. I see we do have some early questions here, which is always great to see. I always like to say this, and I'll remind people at the end, if you do find these sessions helpful, please do remember to like and subscribe to this. Tell your friends, tell your family, for them to come on. There's never too much information you can have with your rights as it comes to your employment, or if you're on a long-term disability or short-term disability claim, you can always give us a call to have any answers you require provided to you. And so we got a question early here from Ryan Marshall. Ryan asks, off YouTube, if you refuse a layoff, can you still get EI? And so Ryan, with that question, it depends on how your employment then ends. If you refuse a layoff and your employer just terminates your employment, then yes, you'll still get EI. If you are terminated for cause, and for just cause, which is it's a very high bar to meet. And I always tell people, if you are terminated for just cause, always call us. It is a very high bar for employers to meet, and because it is the capital punishment of the employment relationship. If you're terminated for just cause, you get denied EI. You don't get any severance. It is reserved for the worst offenses. So for things like serious insubordination, theft, from your employer, and even in some of those cases, there isn't a bright line between one course of conduct and another as to what is just cause and not. There's always a context that it's looked at in, and so you don't lose anything by giving us a call. Typically you can get a free consultation, and we're happy to run through your scenario with you and give you an understanding of what your rights would be in that situation. But Ryan, if you just refuse a layoff, which if it's not a contractual term between you and your employer, and if you haven't agreed to layoffs, in the past excessively, where it's become a yearly thing. For example, if you're working somewhere for 15 years and every April you're laid off for a month and you've agreed to that in the past, that may be an implied term of your employment at this point. But if it's not, if your employer just comes to you and says, hey Ryan, things are a little tough right now, we're going to lay you off for a month or two and see where things sit, you don't have to agree to that. And then that leaves your employer with the choice to place you on the leave anyways. Under the Employment Standards Act, they are permitted to place you on a leave, but you do not have to accept that. You can choose to treat that as a constructive dismissal of your employment. It is a very nuanced and fact-specific scenario. And so, before doing stuff like that, I always tell people, if you're faced with that situation, give us a call, and we're happy to assist you with that. So time frame to respond, I always tell people as soon as you can. Don't go on the layoff. If they say we're going to lay you off tomorrow, call us immediately. If they say we're going to lay you off in a month or two, don't just let it sit. You want to let your employer know that you're objecting, if you are intending to object, and if you are intending not to go on that leave. Do put something in writing to your employer early on, as early as you can, as early as you make the decision. I generally tell people, if you can do it no later than a week after you're notified, that's great. But again, the earlier the better. The day that it happens or the day after that it happens is always great. But do call us, and we're happy to call any employment lawyer. I'm always happy to speak to people. You can find my contact details online. You can drop me a quick email or give me a quick call. I think my number is online as well. I'm always happy to just have a quick chat about things like that. And so Ryan's also asking, can I make a request for requirements of payout? And so I think you may be asking whether or not you can, or I think our QR code has popped up. And so feel free to scan that. If you want to get in touch with me directly, I'm happy to speak with anyone offline as well. And so Ryan, I think you may be asking for like vacation pay or vacation accrual and whatnot. And so if you do have stacked up vacation days and whatnot, you can make a request for that. Just be mindful of any company policies as it comes to payment of that. But if you are terminated, you are required, your employer is required to pay out vacation accrual and any accrued vacation time. So Ryan, hopefully that answers your question. If this is a situation you're actually facing, feel free to get in touch with me and reach out if you have any more specific questions, or if you want to run through your scenario specifically from the ground up. Happy to speak with you. So we have another email question here from Steph. Steph asks, my supervisor blew up at me in front of my coworkers for something that is not my responsibility. Our work is traceable, so I have no idea why she unloaded on me and one other person rather than the people responsible for this issue. What should I do? So, Steph, I'm not quite sure what kind of work you do, and I mean, I'm assuming there's some kind of electronic tracing that can trace back the error or the issue to the responsible parties. I mean, I think here, if it's an isolated incident, I think and it's something that's obviously bothered you. I think it's something you need to bring up with your supervisor or with the company, and you may want to, if there's higher ups, a manager, director, something like that, who is above you and your supervisor. This is something you want to report, especially because any kind of blowing up. I'm taking that as like a verbal altercation, violence in the workplace, verbal violence in the workplace, perhaps, or bullying and harassment potentially. I mean, I don't want to throw those words around casually, but I mean, something like that, if it's a regular occurrence or if it's something that you take in that way or you've interpreted in that way, I mean, it is something to definitely bring up with the company. If it is something that is a regular occurrence and you feel like this is the person's communication style and how they've been dealing with you, and it's bullying or harassing in nature, or it's causing you stress, you may have recourse to things like WorkSafe BC or WorkSafe in Alberta. They have anti-bullying and harassment legislation in place and provisions in their occupational health and safety codes to protect workers from dealing with that, because you don't have to deal with abuse in the workplace. One of the key things I always say to do early on is report it to the company. Report it to the company and request that they do something about it, and at least investigate, and follow up with the company. Do this in writing. Always. So send an email to, again, a manager, director, something like that, and say, so-and-so has, blown up at me or verbally abused me in front of other coworkers. This is something that, if there was issues, could have been done in private, but it wasn't, and it was unnecessary, and kind of detail the interaction or interactions, if this is a regular occurrence, for that person and in the company, and say, like, I'd like an investigation to be conducted, or I'd like you to do something about this. I'd like you to talk with this individual because I don't want to be subjected to this conduct. Have that in writing. And if it happens again, follow up with the company. right? And even if it doesn't happen again, maybe give them a week or two and follow up with the company and say, what's been done here, because I'm concerned about, my job. I'm concerned about interacting with this person in the future. And maybe the company says, well, we've dealt with it, and they'll be giving you an apology or something like that. If you report it to the company and the conduct continues, despite you reporting it, and the company does nothing, you have options as to what you can do. Like I said, you can file a report with whatever WorkSafe organization is in your province. If you're in BC and Alberta, it would be WorkSafe or Workers' Compensation. It would be them, and then they can intervene. Launch an investigation, review the conduct, and make any remedies that may be appropriate. And that can include like sensitivity training, communication training, putting measures in place such as you don't report to that individual anymore, or that individual is not supposed to deal with you. The offending individual is not supposed to deal with you unless there's another person present to ensure that the conduct is above board. There are things that can be done to protect you as a worker. But the first thing is always, write to the company, let them know. I guess the first thing would be to do what you're doing, Steph, is asking for some direction. You can always contact us. I have many people I've talked to when this has occurred to them in the first instance, and we discuss their specific scenario. And many of my colleagues have as well. We discuss their specific scenario, and depending on what type of conduct is being done, how often it's being done, and really what the timelines look like, you may have slightly different ways of going about things to best protect your rights as an employee. But I would say give us a call. Call an employment lawyer. We're happy to speak to you and figure out the best way to set you up and to make sure you're protected, in the event that this continues. And again, if to be clear, if this continues, if this type of conduct continues, it can form a basis for the termination of your employment. As in, you can tell the company, I've reported this to you, and this can be a constructive dismissal of your employment if the company refuses to act on this. Or refuses to investigate it. But again, before going down that road, I always tell people, give us a call and let's chat about this before you go down that road, because there are very specific ways to set up a claim like that appropriately. Okay, and so, Steph, hopefully that answers your question. I hope this was just a one-time thing for you. But if it is something that you foresee happening in the future, call us and we'll be happy to give you a hand and some advice there. So hopefully that answers your question, Steph, and gives you some direction. We've got another question from YouTube here from Stephen Bilks. Stephen asks, I've been dealing with a lot of stress at work and told my employer I was resigning. I later asked to revoke this. My employer refused and said they would accept my resignation. Is there nothing I can do? So Stephen, this is a very nuanced question, a very good question, and to be honest, one that actually comes up quite often. You can resign from a resignation. It really depends on the context in which the resignation was given, and the context in which it was resolved, which you pulled back from it. For example, if you pull back from it the same day or a day later, you have a much better argument that your employer should not be allowed to rely on that. If you pull back from it, a week, 2 weeks, a month later, that becomes a bigger issue. The context in which you resigned and pulled it back is also important. So let's say, for example, we're dealing with a lot of stress. You let your employer know that, and they didn't do anything to, remediate the stress causing issue or event at work. And that, took you to it's called the breaking point. In that scenario, you had enough of it that day. You snapped, you resigned, and that was the context in which it happened. And then you had a chance to cool off for a couple hours or a day or so, and then you go back and say, listen, just flew off the handle there, or the stress got to me, and I've talked to my doctor about it, and I didn't really mean to resign. I mean, in that situation, you've got you've got a better argument for pulling back from that resignation. But Stephen, it is a really, specific discussion that I think we'd have to have. There have to be a lot more details provided. And then, so Stephen, I'd encourage you to give us a call. Depending on what province you're in, give our intake department a call. They'll set you up with someone to speak to. and we can see whether or not you've got a claim to go after for severance. But I think in situations like that, it is not, it's not that all is lost. You do have options, and you will have options. All right, let's see. And so we have another question through YouTube, and it's from PKM Motorsports. And PKM asks, hello, is it acceptable for an employer not to hire a person on the grounds that they believe the person lives too far away from the job, approximately 100-kilometer distance? So PKM, it really depends on, in this case, if you're not hiring someone because they live in a certain area, you're entitled to hire who you want and who you don't want to. You're not forced to hire someone just because they apply. And if you need someone who, for example, you foresee this being an issue, you don't have to hire someone. The biggest thing is you just can't discriminate against people, even in the hiring process. And so you can't tell someone, for example, I'm not going to hire you because you are clearly of, X, Y, or Z religion. That could be, that would be a breach of someone's human rights, discriminating against them on the basis of their religion. But you're not, as an employer, required to hire someone, just because they apply. You can use geographic grounds as a reason not to hire them. For example, if you may need someone on a short notice basis, and you think, well, 100 kilometers is going to take them too long to get here. If someone calls in sick and that's a need your business has, that's fine, because it's for a legitimate business need. Okay, so PKM, hopefully that answers your question. If you do have more specific questions or questions about hiring in general or hiring practices, you can always feel free to, again, give us a call, and I'd be more than happy to speak with you and give you some tips and assist you through that process. And so we've got another question. We've got a couple questions here through YouTube, and it's through Ko Hyunjun, and Ko asks, hi, I've been terminated from work because of conflict with my coworker. Employer kept leaving employees in hostile work environment, making me stressed and made me fight with the coworker physically. Is there something that I can do or any rights that I have that I can ask for against the employer? I believe they have not done a proper investigation and only I got terminated from work. So Ko, this seems like a very high stress situation that you guys were placed in. I'd have to know a little more about the conflict and how the employer left you guys in a hostile work environment. The thing that causes me concern is the fact that this escalated to physical violence. And so we'd have to know a little more about that. The fact that you were only targeted for termination is potentially an issue there, especially if no investigation was conducted. It may not be that gets you out of just cause, but I think if no investigation was conducted, your employer would have to have very clear evidence that, for example, you were the aggressor, or that you pushed this conduct forward, and that you were the one who caused the physical violence. And so, Ko, I think you're going to have to call in with a lot more detail about the situation, how it escalated, how it developed, what reports were made, things along those lines. Okay, and then so we've got another question here. Through YouTube. And it's from T. McIntyre. So T. McIntyre asks, do employment laws supersede mandates? Can an employer force you to get vaccinated? Or are they entitled to your vaccine status? So this was a very, very, T. McIntyre, this was a very, very hot topic, during the height of the pandemic and right after the vaccine mandates were put in place. The employer, the current law in British Columbia, there was a recent case, and it was called Parmar and Tribe. And the current law is that an employer, they can't force you to get vaccinated, but they can put a vaccine mandate in place. Employment laws do not supersede these mandates, according to the court. What that means is an employer can now make it a condition of your employment that you become vaccinated, whether or not that would really fall today or not, depending, given that the pandemic is largely over, and things have returned kind of to normal. there's still a contextual analysis I think that needs to be put in place. For example, if you're working remotely fully, that may get you out of that whole mandate discussion in the current case. But as the law currently sits, is your employer can require you to get vaccinated for COVID-19. Doesn't apply to all vaccines, as far as I'm aware, but they can require you to get vaccinated for COVID-19, and if you don't, they can put you on an unpaid leave, and that will not be considered a termination of your employment. Now, again, that's in a situation, for example, if you work in a office environment, right? You're in an office environment, maybe an open air office or a cubicled office or something like that, but you're in an office environment, and your job can only be done from the office. You would be stuck. But for example, if you work purely remotely, I think you've got another argument there. You've got a better argument. And so, T. McIntyre, I think you should give us a call if you do have that type of an issue going on, and happy to discuss your situation in a little more detail and see what options, if any, there are for you in that situation. And then you've asked whether they're entitled to your vaccine status. Again, I think they would be entitled to your vaccine status, especially if they're linking it to public health or to the health and safety of other employees or yourself. If your employer is implementing this, so again, we should clarify this too. If your employer is implementing a mandate for vaccination for COVID-19, for example, I know you haven't said COVID-19, I'm just assuming, or I'm going to speak in that context, but if they're implementing it now, given the evidence or information we have on COVID-19 at this stage, again, a different analysis may be in place. So I think this is a very specific question. It's kind of a developing area of the law because, prior to COVID-19, this hasn't been an issue. And if you're in a healthcare specific setting, for example, you work in a hospital, it's been legal for hospitals to know your vaccine status and require you to be vaccinated because you're working with vulnerable individuals. But at a base level, no, employment laws do not supersede mandates, especially if they're put out by the government. Those would supersede employment laws unless stated otherwise. All right, and so we have another question here, an email question from Sheena. Sheena asks, what type of medical information is my employer allowed to request for my LTD claim? So, Sheena, your employer is not entitled to really any information from your LTD claim. What they are entitled to do is they're required to put in what's called the plan sponsor statement, which gives your LTD provider, your insurance provider, information as to your income and things like that, job duties and stuff like that. The only time your employers should be requesting information or medical information, and again, this is, I guess, quasi-medical information, is functional capacity. So what your restrictions on function are, what accommodations you may require if you're on a return to work plan, a graduated return to work plan, or if your insurer and you are exploring, and your doctor are exploring such a plan. Your employer may be entitled to know what your restrictions or limitations are in order to determine whether or not they could accommodate safely a return to work plan, or whether the position or type of job you're in precludes that. This is not, they're not entitled to medical information such as diagnosis, what type of illness or disability you're suffering from. They are entitled to information that says, well, you can't, say, sit down for more than 3 hours. You can't stand for more than 4 hours. Perhaps you can't, bend past, 45 degrees or 90 degrees or something like that. You can't lift more than 10 pounds in a 10 pounds at a time, or you can't, do work, with your arms above your shoulders. With your hands above your shoulder level. So they'd be entitled to that type of information, but nothing relating to your actual diagnosis, the treatments you're required to undergo, or what the impacts on your life would be, aside from function. So, Sheena, I hope that answers your question. If you are faced with a situation where your employer is asking for detailed medical information, I would say get a copy of what they're asking for, tell them you'll take it into consideration, give us a call, happy to go over it with you and talk to you about it, and then give you some tips on how to address that with your doctor. Just because your employer, gives you a form to fill out or sends a form to your doctor directly, which they shouldn't be doing either. If that happens, it's not to say that they're entitled to all the information they're asking for. So do give us a call, and we'll be happy to talk you through that. Okay. And it looks like we've got time for a couple more questions here. So if you have any, now's the time to hop on. Got about 3 minutes left here. We got a question from Art on YouTube. Art asks, my insurance has been cut off for the second time this year. I appealed the decision the first time and was reinstated. Does my limitation period start from the first cutoff date or the most recent? Excuse me. So Art, your limitation period, which is the period in which you can sue your insurer for coverage, would start from the date of your most recent denial in this case. The easiest way to look at this is if you were denied and you were reinstated and then you were denied again, that new denial is the date from which your limitation date starts because your insurance was reinstated. While the reasons may be the same that they denied you for the first and the second time, it won't matter. It's the most recent denial. And as you said, there is an appeal process, and sometimes it can be successful. I tell people this is it can be successful. Largely, it's not, because you do have situations where you're going back to the insurer with sometimes the same medical information, when the same individual is saying, essentially, rethink your decision, please, and keep me on insurance. But they do have this internal appeals process. If you do wish to go through it, I always tell people, go through it. And if you are denied again, give us a call. You can always call us before that as well to get some more information on your specific situation and what our thoughts may be on it. That is an option open to you. Okay, and so hopefully that answers your question, and I hope your situation gets sorted out there. We have another question here from Anna on YouTube. I'm going to try to get through this here. Anna asks, I'm on a second round of incident report after filing first when my boss is retaliating on me. I have raised the issues of my general manager making racial comments, consuming drugs and alcohol on the job, and he's trying to push me out. HR is investigating. What can I do to protect myself? So, Anna, that's a really detailed question, and quite a number of concerning kind of issues are raised with that. I think the first thing you got to do is make sure. I'm confused as to why they're putting you on an incident report. I'm assuming it's just from your general manager trying to push you out and just writing you up for anything. So I would say do put things in writing to the company and HR about the conduct you've witnessed and the conduct you've been subject to. When you are written up, protest. I would protest with HR and explain why you shouldn't be written up for that specific situation. I would say give us a call because I want to hear more details about this. And you may have a claim to go to WorkSafe. You likely have, given the fact that you're being subject to racial comments. It would be interesting to know whether this is verbally or in writing, and what other conduct you're being subject to. But you may have a human rights complaint here. It sounds like you definitely would have recourse to go through WorkSafe, because this does sound like at minimum an unsafe and potentially harassing and work environment. So you do have options. The fact that HR is investigating is important and is good. You've done the right thing there by getting HR involved. Hopefully they're going to conduct an appropriate investigation and deal with this appropriately. But I think you're doing the right thing, trying to see what else you can do. The basic things is get everything in writing. Make sure you're never alone with that person. Never have verbal meetings alone. Require someone from HR to be there because they are investigating, and so I think that's important. And give us a call, and we can talk a little bit more. I think we're out of time here, but thank you everyone for joining me. I look forward to seeing you again. We have another session tomorrow in Ontario, and that's with Samara and. Right there, it's at 1 p.m., 1:30 p.m. Eastern Time, with employment law question and answer. Remember to like and subscribe if you find these helpful, and feel free to join at any time and ask anyone any questions. Okay, have a great weekend, everybody, and look forward to seeing you again.